Senator King.
I want to raise an issue that hasn't been discussed. All of you very comfortably asserted that this was constitutional, that the ECRA was constitutional. Mr. Mueller, I think you used the term well within constitutional bounds. I'm worried about the implications of the so-called independent legislature theory. And the theory basically holds that there's a difference, there's a subtle difference between the election clause in Article 1 and the election clause in Article 2. Article 1 says legislatures and the states shall set election rules, but then, semicolon, Congress may amend or override those rules. In the election clause for the president, it talks about the states shall select electors in a manner the legislature shall direct. There's no provision for congressional expressed provision as there is in Article 1. And there are those who assert, and apparently we now have 3 justices, Thomas, Alito, and Gorsuch, who appear to accept this independent legislature theory that nothing can override and they can do anything they want whenever they want. Mr. Bauer, let me start with you, since you're a graduate of the same law school that I am. I'll give you that. I'll give you the privilege of beginning. What do you think of this theory, and is this a concern in the context of what we're discussing here today?
No, I don't believe it is. There's been a lot of different meanings assigned to the term independent state legislative doctrine, but I think one thing is very clear, which is whatever state legislatures may do in the manner of appointing electors, they cannot violate other constitutional provisions. They are still faced with the requirement that their actions be consistent with the Due Process and Equal Protection Clause, with the right to vote under the First Amendment. There are constraints, and I don't think in the most extreme form that somebody might suggest that one might understand independent state legislature doctrine, I don't think that would be an accurate statement of what is available to state legislatures under our Constitution.
Mr. Mueller, your thoughts?
Yeah, so Congress has the power to choose or to define the time of choosing electors. And so one of the really important things this bill does is by eliminating the fail to make a choice provision and saying all of the rules have to be in place as of Election Day, then it puts in place that if you're going to hold a popular election, we're going to follow those rules. And there's no opportunity to show up later and do something else. And so while there might be in the most aggrandized theory of the independent state legislature to say the legislature can do whatever it wants, perhaps that's true, but it has to do it on the first Tuesday after the first Monday in November, and it has to have laws in place well before that election.
So the power in the Congress to set the date is a constraint on the legislature acting retroactively.
Correct.
That's reassuring. Mr. Gore, do you agree?
I do agree that the independent state legislature doctrine is not implicated by the Reform Act. And I agree with Professor Mueller's reasons for that. And I'll just add that this provision that clarifies that the governing law for presidential elections is state law enacted by state legislatures prior to Election Day further allays any concerns there might be under that doctrine.
Do you feel that the Electoral Reform Act